Moral Support N1. Moral reasons for managing a workplace health and safety are: moral reasons are based on the concept of an employer owes a duty of reasonable care to his employees. Society expects every employer to demonstrate a correct attitude to health and safety to his workforce. It is unacceptable to place employees in situations where their health and safety is at risk. An employer has a moral obligation to protect other people, viz., contractors, visitors, or members of public, whose health and safety may be affected by his undertaking. An organization should strive prevention of harm, injuries, illnesses, including mental illness, to workers caused by work. An organization should strive prevention of pain and suffering to others who could be affected, such as fellow employees, family, and friends. Further, the following global statistics published by the International Labour Organization, ILO, also support. More than 2.75 million die from workplace injuries every year. 3.5 lakhs fatal accidents in industries. More than 270 million suffer from occupational diseases each year. 4% of GDP is lost due to accidents, injuries, death. 137% of minors suffer from silicosis, lung cancer, in Gulf of Mexico. 18% of industrial workers suffer from hearing loss, as per WHO. The financial reasons for managing workplace health and safety are: when accident or ill health occurs, there will be direct and indirect costs associated with that event. Direct costs are first aid treatment and medical cost incurred to the victim or workers, transportation cost, workers' sick pay if they are off work, overtime costs incurred to cover their absence, repairs or replacement of damaged equipment and building, lost or damaged product arising from the accident, lost production time while dealing with the injury, fines and compensation payment in the event of legal action, rehabilitation cost incurred on the injured worker. Indirect costs are time taken to investigate the accident, the costs of additional control measures to prevent recurrence and to comply with enforcement notices, costs associated with the training and recruitment of additional employees. There may be loss of morale in the workforce, which could impact productivity. General difficulties in recruiting and retaining staff as a result of the accident. Loss of goodwill of customers following delays in production and fulfilling orders. Damage to the organization's customer relationships and business reputation. Damage to industrial relations, perhaps leading to industrial action, e.g., strikes. When an accident or ill health occurs in a workplace, there will be insured costs and uninsured costs arising out of the event. Insured costs are damage to plant, buildings, and equipment, the repairing cost, rebuilding cost incurred, compensation paid to workers who could not work any longer, or amount paid to the relatives of the deceased worker, medical costs payable to the workers who are on medical sick leave, legal costs associated with a legal claim for compensation. Uninsured costs are production delays or downtime, the time lost in production to start or during operations due to breakdown, loss of raw materials due to accidents, the cost of raw materials lost in accidents, accident investigation time, the cost of wages payable to the investigations team for the hours spent on accident investigation, criminal fines and legal costs incurred due to the successful prosecution of the enforcement agencies, sick pay for insured workers during their medical sick leave, overtime paid to the workers to make up for lost production, hiring and training new employees due to absence of injured worker, loss of business reputation due to delays in production and fulfilling orders. Legal reasons for managing workplace health and safety relates to the framework of international and national laws that govern the conduct of businesses and organizations. They are Health and Safety at Work Act, HASAWA, 1974. We've got the Health and Safety at Work Act 1974, which is a big legal deal. It says employers have a legal duty to make sure their workplace is safe and sound for employees and anyone affected by their work. Management of Health and Safety at Work Regulations, MHSWR, 1999. UK laws requiring employers to assess and manage workplace risks, ensuring employee and public safety by identifying hazards, implementing control measures. Workplace regulations. We've got various workplace regulations, like the Management of Health and Safety at Work Regulations 1999. These rules make employers do risk assessment, put safety measures in place, and give proper training to keep everyone safe. Manual Handling Regulations 1992. UK publication from the HSE that provides guidance for employers, managers, and safety representatives on how to comply with the regulations, which aim to reduce injuries from manual handling tasks. Health, Safety at Work Regulations 1992. They establish key employer duties for a health, safe, and comfortable work environment. Provision and Use of Work Equipment Regulations, PUR. A key health and safety law requiring employers to ensure all work equipment, from basic tools to complex machinery, is suitable, safe, maintained. Lifting Operations and Lifting Equipment Regulations, LOLER. A UK law that sets duties for owners and users of lifting equipment at work, ensuring it's safe, fit for purpose, properly marked, and regularly examined by competent persons. ILO C-155. ILO R-164. To avoid court case. To avoid punitive damages. To avoid enforcement actions. Legal liability. Employers can be legally liable for their employees' conduct if there are injuries or accidents at work due to negligence or not following safety rules. Contractual and tort law. Negligence in health and safety can lead to legal claims through contractual and tort law. That could mean paying out compensation through employment tribunals or the claims courts. Civil liability. Finally, there is civil liability. Employers can face claims from employees or others who get hurt because the company didn't make the workplace safe.
Employers' responsibilities. As per ILO's C-155 Article 16, the basic obligations/responsibilities placed on employers or employer legal duties as per C-155. Article 16. Employers shall be required to ensure that, so far as is reasonably practicable, the workplaces, machinery, equipment, and processes under their control are safe and without risk to health. Employers shall be required to ensure that, so far as is reasonably practicable, the chemical, physical, and biological substances and agents under their control are without risk to health when the appropriate measures of protection are taken. Employers shall be required to provide, where necessary, adequate protective clothing and protective equipment to prevent, so far as is reasonably practicable, risk of accidents or of adverse effects on health. As per ILO's of R-164, Article 10, employers' basic obligations are the obligations placed upon employers with a view to achieving the objectives set forth in Article 16 of the Convention might include, as appropriate for different branches of economic activity and different types of work, the following. A. To provide and maintain workplaces, machinery, and equipment, and use work methods which are as safe and without risk to health as is reasonably practicable. B. To give necessary instructions and training, taking account of the functions and capacities of different categories of workers. C. To provide adequate supervision of work practices, and of application and use of occupational safety and health measures. D. To institute organizational arrangements regarding occupational safety and health and the working environment, adapted to the size of the undertaking and the nature of its activities. E. To provide, without any cost to the worker, adequate personal protective clothing and equipment which are reasonably necessary when hazards cannot be otherwise prevented or controlled. F. To ensure that work organization, particularly with respect to hours of work and rest breaks, does not adversely affect occupational safety and health. G. To take all reasonably practicable measures with a view to eliminating excessive physical and mental fatigue. H. To undertake studies and research, or otherwise keep abreast of the scientific and technical knowledge necessary to comply with the foregoing clauses.
Workers' responsibilities as per ILO R-164, Article 16.
As per ILO R164-16, the obligations placed on employees are take reasonable care of their own safety and that of other people who might be affected by the things that they do and the things that they fail to do. Comply with instructions and procedures given for their own safety and health and those of others. Use safety devices and protective equipment correctly and do not render inoperative. Report to their immediate supervisor any situation which they believe could present a hazard and which they cannot themselves correct. Report any work-related accident or injury or ill health which arises in the course of or in connection with work. Workers' responsibilities, as per Article 19 of C-155. Article 19. There shall be arrangements at the level of the undertaking under which a. Workers, in the course of performing their work, cooperate in the fulfillment by their employer of the obligations placed upon him. B. Representatives of workers in the undertaking cooperate with the employer in the field of occupational safety and health. C. Representatives of workers in an undertaking are given adequate information on measures taken by the employer to secure occupational safety and health, and may consult their representative organizations about such information, provided they do not disclose commercial secrets. D. Workers and their representatives in the undertaking are given appropriate training in occupational safety and health. E. Workers or their representatives, and as the case may be, their representative organizations in an undertaking, in accordance with national law and practice, are enabled to inquire into and are consulted by the employer on all aspects of occupational safety and health associated with their work. For this purpose, technical advisors may, by mutual agreement, be brought in from outside the undertakings. F. A worker reports forthwith to his immediate supervisor any situation which he has reasonable justification to believe presents an imminent and serious danger to his life or health. Until the employer has taken remedial action, if necessary, the employer cannot require workers to return to a work situation where there is continuing imminent and serious danger to life or health.
Powers of factory inspectors as per Hasawa 1974, Section 20. Power to enter in a company under his jurisdiction. Can enter a company with a technical person/constable with him. He can interview any person on H&S. He can take samples. He can take photographs. Inspect any document on H&S. Ask anyone to give health and safety information about the company. Carry out examination and investigations. Secure a place without disturbing for later evidence. Detain any items. He can confiscate any documents from the organization. He can close a particular area/equipment on health and safety noncompliance. What actions labor inspector can take enforcement action after visiting a workplace? Verbal warning, written warning, improvement notices, prohibition notice, deferred prohibition notice, prosecution, fine, penalty, imprisonment. Potential consequences for not complying with health and safety law. Legal penalties. Fines. HGC may face substantial fines imposed by regulatory authorities for breaches of health and safety regulations. Prosecution. Company directors or managers could be prosecuted, leading to criminal convictions. Enforcement notices. Authorities may issue improvement or prohibition notices, requiring immediate action or cessation of unsafe activities. Civil liability. Compensation claims. Employees or third parties injured due to non-compliance can sue HGC for damages, leading to costly compensation payouts. Reputational damage. Loss of trust. Negative publicity from incidents or prosecutions can damage HGC's reputation, affecting relationships with clients, partners, and the public. Loss of business. Clients may choose competitors with better safety records. Operational disruption. Work stoppages. Enforcement actions may halt operations until compliance is achieved, causing delays and financial losses. Increased insurance costs. Higher premiums. Insurance companies may increase premiums or refuse coverage due to poor safety records. Employee morale and retention. Low morale. Unsafe working conditions can reduce employee morale and productivity. High turnover. Employees may leave for safer workplaces, increasing recruitment and training costs. Personal consequences for management. Disqualification. Directors may be disqualified from holding office if found negligent. Imprisonment. In severe cases, individuals responsible may face imprisonment.
Duties and responsibilities of directors, senior managers on health and safety policy. To prepare and implement right health and safety policy in the organization. Provide adequate resources are allocated to establish, implement, and maintain the health and safety management system. This includes sufficient funding to deliver the objectives in the policy, but also competent personnel to assist in the delivery of the policy objectives. Establish right organizational structures with clear roles and responsibilities in the organization. A director or senior manager is appointed with specific responsibility for health and safety so that it can be championed at board level. One or more competent persons are appointed to assist the organization in meeting its health and safety obligations. Contractors are engaged and managed correctly, demonstrating the organization's health and safety responsibility to third parties. The health and safety performance of the organization is reviewed on a regular basis to ensure that the objectives are being achieved and that the objectives and measures in place remain valid. To provide downward and upward communications. Integrate health and safety management systems in the organization. Demonstrate clear commitment and leadership on health and safety. Involvement of workers in H&S. H&S training. Keep up to date the health and safety policy. Keep and update SSOW, SOPs. Responsible for carrying out monitoring and carrying out health and safety audits. 16. Arrangements for carrying out accident investigation. Annual review of H&S performance. Shared responsibilities in joint occupation, a premise. Required procedures and manage works in joint operations. Carry out risk assessments and share the risk assessments. Exchange of relevant information. Effective communications to all. Cooperate and coordinate with each other on the activities. Carry out joint inspections on hazards and risk. Do mutual drills. Discuss on the fire, explosion, and other emergencies. Mutual agreements like LOTO. Shared responsibilities when contractors are working a workplace occupied by employer. Emergency arrangements should be adequate. The landlord will have the overall responsibility for the integrity of the building and for the routes in the building that enables their renting the offices to get to the part they are renting. Selection of contractors. It is a good practice to select a contractor carefully on the basis of their health and safety competence. The criteria to assess the suitability of a contractor to see evidence of competence are: obtain a copy of their health and safety policy of the contractor, HSMS of the contractor, safety manual, procedures, SOPs, risk register, permit to work systems, audits, site inspections, internal HSE audits, review meetings. Resources of contractor. 4M. Men, machine, money, and materials. Obtain and see risk assessments and method statements. Whether the contractor possess approved HSMS. The qualifications and training records of staff. Check the resources for 4Ms: competent men, machine, safe, material, quality, money. Access egress management. Traffic management. Legal documents, legal register. Monitoring arrangements. Inspections, light or noise monitoring, personal monitoring. Membership of a professional organization or certified body. Records of maintenance and test for plant and equipment. Names of previous or current clients to use as references. Accident history records. Accident history records are records show the incidents occurred in the workplace. Check LTI rate. Refer the accident history records and calculate the LTI shown by the contractor. Check risk register, inspection records, and instruments records. Records of enforcement action taken by authorities against them. Proof of adequate resources, such as access to specialist safety advice. Check for public liability insurance available. Xeon International Safety College, WCC Road, Nagercoil, 90808 65511.